Good afternoon, everyone. My name is Christopher Higgins. I'm an attorney located in East Brunswick, New Jersey, and just taking a few minutes today to talk to you about a Chapter 7 bankruptcy filing. Important note, if you're located in a different state, the rules are going to be different. So obviously, this talk is not intended to be a replacement for speaking with an actual experienced bankruptcy attorney. So I strongly recommend you do that before making any decision one way or another. But the crux of what bankruptcy is you have a lot of debt. You make X amount, but X amount is in no way going to allow you to pay off your debt within a reasonable period of time, at least a period of time that would satisfy creditors. And the purpose of a Chapter 7 is it's a liquidation. You go before the court and say, I make this, I owe this, I can't pay back my debts, I would like my debts discharged. And in most cases, debts can be discharged. Some exceptions, and there are numerous exceptions, but for the most part, your credit card debt, your medical bills, any unsecured debt can be wiped out. Your secured debts, such as your mortgages and your car loans, your personal obligation to pay those will be wiped out. Personal obligation is an important note because the lien on the asset, be it a car or a house, that remains, and the lender does and will have the right to assert their rights in the property either by a foreclosure or repossession, but post-discharge, your obligation is nil. Now, a lot of people wonder about tax debts. Can my taxes be discharged through bankruptcy? And again, I must note, your state may do it differently than New Jersey. The general rule is 3 years from the date of filing for federal returns and 2 years from the date of filing for state returns. Not the date of the actual tax year, but the date you filed it. So if you have unfiled taxes, regardless of whether they can be discharged or not under this process, I would get them filed as soon as possible to avoid any unpleasantries going forward. Now, what can a bankruptcy attorney do for you? Why do you need to hire? Why should you hire one? You have an absolute right to represent yourself in any legal proceeding. Why should you hire an attorney for a bankruptcy? I would suggest that you find your local state's bankruptcy court website, and there should be a link to what the rules of bankruptcy are. They are very complicated. There is a lot of room for error. There are a lot of things that can go wrong, and an attorney that knows their way around the law is able to best help you in this process. Now, how do you go about finding one? Google search, the newspaper. There's a lot of websites out there that give kind of directories of attorneys in various specialties. Now, how's the bankruptcy process going to work? Your bankruptcy attorney, and regardless of who you retain, whether it's someone that's been in business 20 years or 20 days, they're going to want certain financial documents, tax returns, your pay stubs, bank statements, information on your house value, your car value. If you have anything of a unique nature in your house, such as a stamp collection or a painting, and most people don't, but those have to be disclosed if there are. You put all that together, you make up a list of income and expenses to determine where you fall into. And this is important because there are rules in the bankruptcy code that say that if you make over a certain amount of money, that can affect what chapter you file for. You may be ineligible to file for a Chapter 7, in which case you are essentially thrust into a Chapter 13. That's a discussion for another day, and I'm not going to get into it right now. But ideally, once the petition is filed, the attorney will have filed the petition. One more thing you'll have to do before that is done is you'll have to complete what's called a credit counseling certificate. All bankruptcy attorneys know the companies that do it. This is part of the laws, and this is not something that an attorney such as myself is going to profit from. The law says you have to complete this course prior to filing a bankruptcy petition. And whenever you go and talk to an attorney, they'll guide you to the right direction. Now, once you file, you get an automatic stay. And what this means is anyone that's trying to collect a debt from you anyone that has a judgment is trying to take you to court, that all stops. Again, with some exceptions. If you get a traffic ticket while you're in bankruptcy, you can't use the automatic stay to stop that. But I would say 95% of all legal proceedings are halted by virtue of the automatic stay. About 4 to 6 weeks after you file and get your case number, you will then go to what's called a meeting of creditors, and that will be before a trustee, who in most cases is an attorney, such as myself, who has vast experience in the realm of bankruptcy, and who is assigned to administer what's called your bankruptcy estate. It is your financial affairs, your assets, your debts. And it will be an interview, essentially under oath, tape recorded, where they look to see what's going on with you. Is there anything that might have been left out? Do you have any assets that you may be entitled to, like an inheritance or a personal injury lawsuit? Creditors will at that time have the ability to appear and ask questions to determine what's going on with your case. In my experience, they don't normally show up. But every case is different, and past experience does not predict future results. So you'll do that. Ideally, it's a 5 to 10 minute interview. But again, I'm just going on based on what I know in New Jersey. Any other state might do it differently. So again, it's beneficial to you to contact local counsel to determine how things proceed in your state. That having been said, after this meeting of creditors, there's a second course you have to take, which is much like the first one, the credit counseling I mentioned before, and it's called a financial management course. By law, you're required to take that course. It's a 2-hour course. You use whatever the same website as you used before. Again, your local attorney will help you. They will guide you in the right direction. And ideally, about 2 months after this meeting of creditors, you will get your discharge in the mail. And what it discharges is your obligation to pay all unsecured debts, which are essentially credit cards, medical bills, and what have you. Tax debts depending on how old they are, and your personal obligation to pay secured debts, i.e. your mortgage, car loan, and similar things. It will not take the mortgage off the property. It will not take the lien off the car that the lender has placed. At that time, what you choose to do with an asset like a house or a car is completely up to you. And ideally, you would have discussed this with your counsel before even going into bankruptcy, but that's another discussion. But you'll get essentially what's called a fresh start. Your credit will have suffered, but over time, if you build your credit back up, about 7 to 8 years, as long as you make good on everything, it will be as if the bankruptcy never happened, but it will never come off your permanent record. It will never come off your credit report, to put it another way. So that's pretty much a Chapter 7 bankruptcy in the bare bones nutshell. Obviously, it's a lot more in depth than that, as any field of law is, but just for the general, general here and now, that is how the process should work ideally. Again, every bankruptcy is different. Every person's individual situation is different. Oftentimes, a husband and a wife, their situations are radically different from each other. So, contact a local attorney in your area. There are dozens, hundreds of resources out there to help you find someone that can help you with your individual situation. And I wish you well. I wish you best of luck. And help is out there. Now it's not too late to consider wiping your debt out in that regard. Thank you.